The ruling that's bound to have implications and complications for many. The judgment upholds a High Court ruling that ordered SARS to supply the Financial Mail and AmaBhungane with the tax records of the former president. Now, Parliament has 24 months to amend the legislation. AmaBhungane's advocacy coordinator, Caroline James, joins us now for reaction in studio. Caroline, thank you very much for coming in studio. This is obviously a long time that you've been battling this whole case. It went from the High Court to the Constitutional Court, and finally there's a ruling. And this is, I assume, not something positive only for the media, but for the public as well.
Yeah, absolutely. I think you're correct. I think the reason the media brought this application was to ensure that the public had access to important tax records of highly important people that have an impact on our daily and political lives.
And of course, what's important is that the Constitutional Court found that Section 67 and 69, that's obviously the Access to Information Act, goes against Section 32, which says anybody has a right to access information that is with government. So it extends beyond the media, right? When somebody makes an application that they feel they need access to, especially records that are with government.
Absolutely. So as you mentioned, it's brought about within the bounds of the Promotion of Access to Information Act, which anybody can use, whether it's the media, individuals, ordinary citizens can apply now to SARS for information relating to an individual taxpayer. But it's important to note that the judgment limited it to SARS will only grant the application in situations where it's very clearly in the public interest for that individual's taxpayers' records to be disclosed.
That's very good clarity. It doesn't mean that you and I, if there's a lover's quarrel, I can just go ask for my partner's tax records. But they've also given Parliament 24 months to amend these two legislations and enforce what they've said, which means it has to go in there, it needs to become an amendment bill, voted for, etc. So does it mean that you can already go to SARS now and ask for those records, or do you have to wait for it to be amended? Because at the end of the day, that's still the law for now, right?
So what the court did two things. As you say, it referred it to Parliament and gave them 2 years to correct the unconstitutionalities within the legislation. And as you say, that'll be full public participation. It'll go before Parliament and be debated. But in the meantime, the court read into those two pieces of legislation elements which ensure that that public interest is given effect to in those laws. So from today, from the time that the judgment was handed down, an individual can approach SARS under the Promotion of Access to Information Act and seek that information, justifying why it would be in the public interest to do so.
Right, let's remind the viewers the context of this entire application by AmaBhungane in terms of investigating. This came from a book written by investigative journalist Jacques Poe, who said in his book that the former president was evading tax.
Yes, so there were allegations in Jacques Poe's book, The President's Keeper, that President Zuma had not been tax compliant. And there were questions about whether he'd been declaring all his income to SARS. And at that stage, there's still allegations. And because SARS had such an absolute secrecy regime, which the purpose behind that is to protect individuals' privacy, it meant that those allegations could not be tested. And so the Financial Mail and AmaBhungane approached SARS in a way to investigate whether those allegations were actually correct, and sought the access to his records to see whether he had disclosed all the income he'd received, whether there were any payments that were coming in from individuals that might indicate some additional criminality.
Is this also something that could extend, example, to another scandal we've seen with the current president in the form of Phala?
I certainly think so. I think that the important part of this judgment, and one of the reasons why we brought this, it goes beyond President Zuma and the allegations of corruption around him. It's the concept of transparency and accountability, and that high-profile people who their financial affairs are of relevance to us because of the decisions that they may make because of income they're receiving, that needs to be transparent, and we need to be able to hold high-ranking politicians or businessmen with high influence to account, and to ensure that we are able to see that information. It shouldn't be hidden behind a sort of veil of secrecy that our previous SARS regime was.
That was actually going to be my next question to you, that by high-profile people, obviously as media, we know that our job is also to hold Parliament or government officials to account, but that's not where it ends. There's also business people that we have to hold to account. I mean, for example, I think of someone like Marcus Jooste.
Absolutely. I mean, I think so often we have got caught up in this idea that corruption is only one-sided and that it's only from the state. But we recognize that corruption and other financial crimes and malfeasance, there's always a private sector partner in it. And I think that this should also demonstrate that now, as you say, those businessmen can also no longer hide behind the protection that the SARS secrecy regime created, because they must now also be held to account. It might be slightly different in that they don't have constitutional obligations in the way that former President Zuma or the current president do, but they are still accountable in a way that the public and the media should be able to interrogate what their financial relationships are.
But also, Caroline, I don't know, this also begs the conversation of how young our democracy is, right? In terms of, and I don't want to give government the excuse, because that's the excuse that they always give us when they don't give services sometimes. They'll say, we are only 30 years, or previously it was 25 years into democracy, etc. But it also just brings that conversation back, right, where we're still learning, especially in terms of our constitution, that there are some, rights in the constitution that we have to amend because they have to complement each other.
Absolutely, and I think that the judgment touched on that really in a really clear and concise manner, in that it said both parties had mentioned that the UK and Canada also has an absolute secrecy regime, whereas countries like the Nordic countries have an almost completely open tax regime. Individuals can find out, as you say, about a lovers sort of quarrel. But what Judge Collopin really highlighted is that it doesn't matter what the other countries do, it's what our constitutional framework requires. And I think that we have learned from our horrific history that access to information and transparency and accountability is crucial to ensuring that we can realize the constitutional project. And so he built on that, saying, this is what our constitution says. This is what we believe our constitutional society should be, and that society should not allow the individual privacy rights to always outweigh the public interest in understanding information about the financial positions of individuals.
And of course, the legal team at SARS can't go back and try and reverse this decision by the Constitutional Court by going to the Supreme Court of Appeal?
No, the decision is final, but what the court did do, and it changed the High Court ruling. The High Court ruling had ordered that the Zuma's tax records must be immediately released. What the Constitutional Court did is send that decision back to SARS.
Yes.
So it has given SARS 30 days in which to make a new decision based on the application on whether they should be disclosing those records. And they have to bear in mind the judgment and bring in an sort of take an interpretation of both what the judgment said and what the new provisions will say in determining whether there is that public interest to disclose those sort of 8 years of President Zuma's records.
Yeah, it is the apex court after all. So maybe in about 30 days, a month, we'll start seeing some of those articles.
I hope so. We'll have, obviously it is in the hands of SARS, and there are still quite high levels that they have to pass. You know, the public interest override in PIA doesn't make it completely easy to say that the public interest applies in that case, but we believe SARS will apply its mind based on the decision, and we'll see in a month.
All right, at least it's not 24 months.
Yes.
Thank you very much for speaking to us and coming into studio. That was Caroline James. She is the AmaBhungane Advocacy Coordinator.